Oh, okay. I thought it was supposed to be a light there, but okay. I've submitted my testimony, and a lot of what I was going to say has already been mentioned, so I'm going to try to hit the things that I don't think have been mentioned, and a couple of other things. We heard some statistics earlier that a lot of the gun crimes are not being prosecuted in Rhode Island. They're being dropped, and then someone else mentioned, I think it was former Representative Finn, mentioned that they are taken to federal court, and therefore the statistics are skewed a little bit. So my question is then, well, if the gun crimes are not prosecuted under state law, but they move into federal court, what's the point of trying to implement more state laws if they're not prosecuted under the existing ones? On 7243, which I'm opposing, one thing that has not been mentioned yet is that someone will be more vulnerable. Hold on a second. This is the school bill. If you're not able to carry a gun on schools, someone will be more vulnerable if they have for example, a restraining order against another person, because they will know what time and where they will be unarmed and unable to defend themselves. And that doesn't apply just to, when they're picking up the child at school. It could be at a track meeting, it could be anywhere on school property. It's a pretty broad definition of that. So I just want to point that out. And then that's been covered. Oh, on the 7799, which I'm also opposing, it has to do with removing any firearms identifications. Most guns, as you know now, well, most every gun has a serial number on the frame, which you're required by law to have now. However, a lot of gun manufacturers also put the same serial number on the barrel and the frame. You're not required to do that, but under this law, if you need to replace the barrel, barrels wear out eventually, after 20,000 rounds or whatever, you need to replace the barrel. It's nothing, I don't think that should be prohibited to do that, but this bill would make that illegal. On 7850, which I'm also opposing, will severely restrict where you can carry rifles and shotguns, and actually be more strict and more regulated than for handguns if you have a carry permit, because with a carry permit you can carry pretty much anywhere, but that would not cover you for rifles and shotguns, so it would be more restrictive. And back to 7390, which is the carry bill, which I'm supporting. I know we talked a lot about this, but I would just want to talk a little bit of my own experience, and this is actually how I got involved in gun rights. In 2010, I started my process to get a permit from Newport. At the time, they did not have an application. I was told for a couple of years that they were working on it. They never gave me anything. It wasn't until I actually filed a suit in Rhode Island Superior Court, similar to what Jim did. As soon as I filed it, then he gave it to me. So he probably was sitting on it for a while. He just didn't want to give it to me. It was pretty much the only way I can get one. And I know there were several other towns that were sued for the same reason. So that was like 2 years went by. I finally applied, and I was denied. I was trying to find a date here, but I don't have that. There was like a couple of years later, I was denied my permit. And the reason for that was that I did not demonstrate, I didn't have a proper showing on need, which there's no proper showing on need in 114711. As you probably know, that the Gadomski decision clarified that in East Providence, the chief applied the wrong standard. You don't need to demonstrate on need. I petitioned the Supreme Court for a review as well. They had taken a couple of cases. They had taken the Gadomski case, and they had taken accepted there's another case in Bristol, I believe, Gendro. But to my surprise, they didn't accept my case. They just denied it. They didn't say why. They just said my petition for cert review was denied. So even though the Rhode Island Supreme Court said in the Mosby decision that appeals should be going to the Supreme Court, the same court denied my appeal. So now I have no way I have basically exhausted all my my appeals. I have no other avenue, and even though it is a shall issue permit, and I meet all the statutory requirements, I still don't have my permit. One more thing, I was actually, after the Gadomski decision, the chief actually agreed to reconsider my application, because he denied me for the same reason as Gadomski was denied. But again, he denied me for basically the same reason. He just worded it a little bit differently. He said that I didn't have a good and proper reason, I think. I don't have the denial letter here. But he felt that because I didn't demonstrate an immediate threat to myself, I didn't have a proper reason. I met with him for an hour and 45 minutes, and he acknowledged that self-defense is a proper reason. They have issued permits in Newport for self-defense, but since I didn't demonstrate a specific threat, he didn't think that I had a proper reason. I thought that was kind of a little strange argument, but that's why I think it's important that we pass this bill here, and we can have guaranteed appeals with Superior Court. And they can review the case and see if there's anything that's been processed incorrectly. So that's pretty much all I have. If you have any questions, let me know.